Welcome back to News Talk. If you've ever been called for jury duty, and who hasn't, you may find yourself wondering about the juror selection process. Why do some potential jurors get struck while others remain? Attorneys are not supposed to use race as a criteria, but they do, all the time. This is one of several interesting legal issues we'll discuss today with attorney A. Scott Bolden of Reed Smith, Washington. Welcome back. It's good to have you here.
Hey, Bruce. Thanks for having me.
There was an article in the paper that detailed this just the other day. I found it very interesting, both in an academic sense, but also, you know, most of us get called for jury duty from time to time. If you find the law interesting, the juror selection process is often our only connection to what happens in America's courtrooms, in the region's courtrooms each day.
Unless you're a party.
Yeah, right. Which for most of us, we're just as happy not to be.
Right, right.
But you know, I've been there. I've been struck. What, if any, is the legitimate role of race when attorneys are sitting there with their clients alongside and they're looking at these people, most of whom they know little about, and they say, okay, you stay, you go, you stay, you go, etc.
Well, race is not supposed to play any part other than the fact that we are all a very racially diverse society. At the same time, what the Supreme Court has said under Batson v. Kentucky is that you get peremptory strikes. And these peremptory strikes, you don't have to give the court a reason. Striking someone for cause, there is some bias or prejudice or some risk of that in keeping that juror. And so it's by jurisdiction. Sometimes you have 3, 5, even up to 10 peremptory challenges in some jurisdictions. Okay, so the basis for that peremptory challenge has to be a race-neutral question if the court asks you, or if the opposition, the defense counsel in a criminal case, if the defense counsel challenges you removing that person by using a peremptory strike. And so it has no role in it whatsoever. It shouldn't, at least.
Let's go to the outset, talk about the issue generally, and then come straight back to this issue of race. Why are there any peremptory challenges? Why not have a process where people get called to jury duty at random, the names get pulled out of a hat at random in terms of who from that large room that we've all been in, that jury pool, you know, that juror lounge, they call it,
Right.
So you go, why isn't it the first 12?
Well, it dates back to the early days of England. You know, our jurisprudence system was brought over from the UK during the 1800s. And that being the case, it's always, quote, kind of been done that way. But the underlying policy and consideration is that you want to pick a fair and impartial juror. And so both sides get to strike jurors for cause, and then it's kind of like a lottery, if you will. They'll give you 3 or 5 peremptory strikes because for whatever reason, it can't be racially based, but it can be because you're from a certain community, or you were raised a certain way, or your profession, or anything that is not racially driven here, in an effort to give you extra strikes to try to get the jury that each side really wants. I don't really think it has a whole lot of value in it. It would undermine the judicial process if you took it away. At the same time, though, I do think we're better at it, but we would be pretty good without it also. Doesn't that sound like a lawyerly answer?
A little bit.
It really does. But the reality is it's been there. I think it's helpful. I've tried 50 to 75 cases myself, and I use all of my peremptory challenges because I want the best shot at convincing a group of strangers to believe the story and the facts and the evidence that my client is presenting. And if that goes into that judicial process and helps, and I think it does, we're probably going to be stuck with it.
You all who are in the trade are basing your decisions, it seems to me, and please correct me if I'm wrong, on the most like skeletal of information, right? Appearance, dress,
politics.
Well,
look.
But is politics part of the mix?
Well,
Do you know who's in one party?
No, but if you're a 45-year-old man and you are an executive with a major company and you have a mortgage and you have 3 kids, 2 have graduated from college.
They know all that?
In most jurisdictions you know probably a lot of that, or you can surmise it, if you will. Even if you think that, for example, if you're balding, no matter what race you are established, you've got a job, you're presumed to have a house, you're probably more conservative than the 20-year-old who just finished college and lives in Alphabet City in the Lower East Side of New York. prosecutors, when I was prosecuting in New York, anybody from the Lower East Side that was younger than 40, if you will, or even older than 40, we probably didn't want them on the jury because we believed that they had a much more liberal approach and were disbelieving of the police as opposed to someone who was established, who had a mortgage, had grown kids, and also, you know, if you're married for 20 or 30 years, all conservative type values. And yes, you get to ask the jurors questions, and those questions that will yield you even additional information in the basics that the courthouse has.
Jury duty is one of the few universal experiences we all have as a society, and I always find jury duty stories kind of interesting. So if you want to join in with any thoughts or comments or concerns that you have about the issue that we're discussing here today with Scott, first and foremost, join us with that at 703-387-1020. But if you have a brief, interesting jury duty story that goes beyond, throw it our way at 703-387-1020. To the phones will go as your questions and comments.
And by the way, Bruce, you know, I've served on 3 juries. You know, here in the District of Columbia. In New York, lawyers can't serve on juries. You're never called because statutorily you can't do it. D.C. is completely different. I've served on 3 jurors. Each jury wanted me to be the foreman, and I turned it down each time. I was surprised that I was even selected because I do majority criminal and civil defense work. But I turned down the foremanship of those 3 jurors because I didn't want to unduly influence the jury within the jury room simply because I was a lawyer, if you will. And I did want to be a fair and impartial juror, even though I've done both plaintiffs and defense work. I do majority defense work, and yet both lawyers on these civil cases chose me.
If judges are sitting there and they're watching and they're shepherding this process and they think I mean, it could be that it's so common, even though it's not supposed to be happening, that everyone's just numb and immune to it. But if a new judge, you know, fresh out of judge school or whatever, or anybody says, "Gee, this feels racial," do you blow the whistle? Do you intervene or inquire?
Well, if you're the judge or if you are on the defense side, the defense can always object to that peremptory challenge, saying it's based on race.
But they could be doing the defense could be doing their own race.
The prosecutor has to raise the objection. Or I've seen in a number of cases where the judge raises concern, which triggers an objection, or the judge in most jurisdictions can raise the issue and ask the prosecution or the defense attorney. That's a peremptory challenge.
What happens then?
What's the basis then? Well, if you're whoever is being challenged has to give a reason, and that reason cannot be based on race. Now, the case that's coming before the Supreme Court, the defense counsel, they actually, through a FOIA request, essentially, were able to get the notes of the prosecutor. I don't know why the notes of the prosecutor are still available, let alone being turned over or produced. That would never happen in D.C. or New York because we just wouldn't keep those. But in these prosecutorial notes, they are numbering, they are using the letter B by each name of an African-American juror and saying B for black, presumably, and no. And so the prosecutor struck all 4 of the remaining jurors on this jury pool, which is why the defense has appealed and is seeking to have the prosecution or the conviction overturned, which is sufficient basis or reason. Now, the notes can be interpreted a lot of different ways. You're looking at it in a vacuum, but it's enough to get to the Supreme Court, and the Supreme Court's going to take it up, and it's the first time they've taken it up since Batson v. Kentucky, when they found it illegal to use race as a factor.
I have 30 seconds to a hard out. No, this is fascinating. Right. Could something big come out of this Supreme Court? I mean, it sounds like a stupid question, but is it? Are folks like you sort of tracking this case?
We are, because the judges have an opportunity to go beyond Batson v. Kentucky. You could have the peremptory challenges eliminated altogether, or you could have some other system put in place to prevent this type of private, personal racial profiling that occurs but shouldn't.
Hey, Scott Bolden, stand by for just a moment, if you would, please. We'll continue our conversation with Scott in just a moment. We pause here to update the hour's top stories and more, and then later in the show, we'll talk with Virginia Governor Terry McAuliffe.